Welcome back. There is a new update and in fact a new twist in the sedition debate. The Law Commission is against scrapping of the sedition law. In fact, the Law Commission is of the view that the sedition law needs to be made more stringent. So the Law Commission wants, in its report that it has submitted, is of the view that Section 124A should be retained with certain amendments. Let's go across to Harish to get more details on the amendments that the Law Commission is recommending. And one gets the sense, Harish, that the Law Commission, in fact, is not just backing the sedition law, not just wants it to be retained, but also to be made more stringent.
Yes, good morning, Swati. That's very right. The Law Commission is not just merely backing the sedition law. It wants the law be made more stringent. That is, it says that the minimum punishment, which is at present 3 years, should be increased to 7 years, and the maximum punishment as it is life imprisonment. And all this is coming at a time, Swati, when the debate on whether the sedition law should be scrapped at all is raging in the country. And very importantly, Supreme Court had asked the centre to review the sedition law, and had very significantly last year May put on hold the sedition law, the operation of the sedition law. Now this Law Commission in its report says sedition offence should be retained with certain amendments. The Law Commission, as you rightly said, proposes that minimum punishment for sedition offence be in fact increased. Wants minimum punishment be increased from existing 3 years to 7 years to protect unity, integrity of the country, and also very importantly says to curb radicalization, especially through the social media, which is rampant. It says sedition being a colonial legacy is not a valid ground for its repeal. This comment is very important, as Supreme Court had asked the centre how long it proposed to keep the archaic colonial law, which the Britishers used to suppress freedom movement in the statute book. So Law Commission now says it had received a reference from the Home Ministry in 2016 for a study of the sedition law and suggests amendments, and that is why it has filed a report.
All right, Harish, stay on with us. In fact, we have accessed the Law Commission report, and I believe my colleague Shivya is joining us with more details on the report. Shivya, over to you.
Yes, so as far as the report is concerned, it details out as to what are the grounds on the basis of which such a recommendation has been made. One, it has been said that it is needed to safeguard the integrity. It says the continued existence of the government established by the law is an essential condition for the security and stability of the state. In this context, it becomes imperative to retain Section 124A and ensure that all such subversive activities are nipped in their incipiency. It also says that sedition is a reasonable restriction under Article 19 of Para 2, and the contention, it goes on to say that Section 124 is a violative of Article 19 of the Constitution, does not hold any ground because of multiple reasons, and these reasons that have been listed by the law panel further coming in support of this particular law. It also says that the First Amendment of the Constitution incorporated the words public order, friendly relations with foreign states, and perhaps, as Harish also mentioned, other reasons that have been listed by the panel is that existence of counter-terror legislations does not obviate the need for Section 124A. On the other hand, this makes it more important why it should be retained, and sedition being a colonial legacy is not a valid ground for its repeal. As we know, Swati, this is the ground on the basis of which many such contentions have been raised by many of the parties as far as sedition law is concerned.
All right, Shivya and Harish, thank you for getting us those details. With that, we are slipping into a very short break where a lot more is lined up on the other side. Stay on with us.